Sue.
SJC-10790, Salem Police Department versus Sullivan.
If it please the court.
Hold on just one moment. Sue.
She's off.
If I may proceed,
All
Your
right,
Honor.
Mr. Sullivan, yes, please.
Thank you. If it please the court, my name is Ralph C. Sullivan, and I am the appellant and the defendant in this case. I want to begin by thanking this court for taking this case on your own motion, sua sponte, to consider the issue of the court fees that are at issue in this particular case. I'm here on behalf of myself, but Your Honors, I'm also here on behalf of all of the people who are out standing in line in all of the district courts throughout this Commonwealth every morning, waiting to hear and be heard by a magistrate on the question of whether or not they are responsible for a motor vehicle infraction. And I'm here to present an argument that addresses the change to Chapter 90C. We're talking about Section 3. The legislature enacted an amendment by way of the budget in the summer of 2009 that imposed for the first time fees upon individuals who are charged with a motor vehicle infraction, a civil motor vehicle infraction.
Is it your position that they could not do that? They didn't have the authority to do that?
That is my position, that the imposition of fees to motorists who are charged with a civil motor vehicle infraction, that is a denial of their right to access to the court under Article 11 of the Massachusetts Bill of Rights.
Your whole brief is focused on equal protection, correct?
It is largely focused on equal protection. That's the alternative argument.
Largely? Oh, I thought I read it, that was really what it was focused on. I understand that below you argued due process, but...
Well, that's a twofold argument, and it's referenced in the briefs filed by the amicus respondents as well. And that is and I thought that the reason that this case was taken by this court, together with the Gillespie matter, is that the issue presented was the rights of the citizens to have access to our courts. And so, yes, I do present an equal protection argument, which deals with the issue of whether or not this statute, which imposes fees upon it's a $25 fee to be heard by the magistrate in the first instance, and then to be heard in a trial de novo before a judge, is a denial of equal protection. The arguments on that score are that this category of civil litigants, that is, individuals who are required to pay the $25 fee, are treated differently and irrationally from another category of people who receive tickets and who are also charged with a criminal offense. With
respect to the irrationally part, yes, they may be treated differently, but it's a rational basis test, which you agree.
Yes.
The Commonwealth, and so it's, any conceivable basis that's going to justify these distinctions. And the Commonwealth, what's wrong with the justifications that the Commonwealth offers for whether it's the civil and criminal together, or marijuana, or a variety of others that you have referenced in your brief?
Well, if the rationale is to prevent frivolous appeals, I guess, or if the fee may be imposed upon litigants and the argument that there could be a waiver if someone is indigent, and the other argument they're making is, well, the judge, on some circumstances, is hearing the criminal case at the same time that he is hearing the civil case. But that isn't necessary. The statute also provides that matter may be severed where justice requires from the criminal matter that's being heard at the same time.
Right,
so
but then wouldn't the fees apply to the civil part?
No.
You mean if it's later. But, well, let me just ask you this, though. With respect to the civil only, the Commonwealth says it was rational to think that there would be a lot of appeals, and in fact, the numbers say that there are a lot of appeals, and that it is rational to seek to recover some of the administrative costs of administering the system. And that, quite apart from the question of frivolous appeals, it's just this is one of the provisions, whether because it has an impact on your insurance rates or whatever, it is one of the statutes that imposes a civil infraction fine that generates a lot of appeals. So it is not irrational that the Commonwealth should seek to recover some of that.
My conduct in the alleged lane violation would be identical to another person who received the same offense, but who may have been charged, say, with a crime at the same time. I'm treated disparately from that person for no rational basis. That is, that person doesn't have to pay any fee whatsoever to have their case heard.
Because they've been charged with a crime.
Well, they are, and there's no rational basis for treating me differently from the person who was charged with a crime than there was in the Murphy case with the Division of Industrial Accidents, where this court found that categories of litigants who have attorneys shouldn't be treated any different from categories of litigants who are not represented by counsel in connection with workers' compensation claims. So the argument is that a person who is charged civilly with smoking in a public place, or if they're charged with possession of an ounce or less of marijuana, which is also a civil offense, each of those individuals can appear before the district court judge without the payment of a fee and have that case heard. And those are also civil matters, as was the case in which I was charged with this motor vehicle infraction.
So if the state had charged those people who were criminally charged as well as charged with civil infractions, if the state charged those people with the $25 fee for processing the civil infraction hearing, you wouldn't have any complaint?
Well, it would certainly weaken my equal protection argument, Your Honor, which is only one of the two arguments that we're making. But yes, if there were such a fee charged, which the statute doesn't provide for, and which the Commonwealth admits in its brief, doesn't give rise that there is no requirement of a fee in that instance.
You don't see a difference between a civil infraction fine and instituting a criminal prosecution that might cause a difference in terms of whether the defendant has to pay something?
What I'm saying is that when a criminal defendant is charged simultaneously with a criminal defense as well as a civil motor vehicle infraction, that certainly the criminal component should go forward without there being a fee. That's always been the case in the Commonwealth. But why in the world is the...
Because they're connected.
They're separate offenses charged under separate statutes that are concurrent with each other.
But you can kill two birds with one stone, as it were. It doesn't necessarily add to the cost of the processing of the criminal case to also tag on the civil infraction.
Except in the instance, as Your Honor certainly knows, in the instance where justice requires that the civil matter be heard separately, and the statute provides for it to be heard separately.
But we go back to the rational basis, and you don't have to solve all the problems all at once. I mean, it strikes me as that's not of the level of irrationality to draw that distinction that one would think it violates equal protection.
My argument is that it does, and that is that I'm treated entirely different from a person who committed the same offense. I'm required to pay a fee. That person appears before the court, the same judge in the same courtroom that I appear in. They do not have to pay a fee. On the day I appeared at the Salem District Court, there was a courtroom full of attorneys and litigants, defendants before the court. And I was the only one who had to pay that day to be heard by the court on my civil motor vehicle infraction. Everyone else was being heard at no cost. And that really goes to the issue of really the access to the courts issue, which is the alternative argument, and that is the reference to Article 11, which states that every subject of the Commonwealth ought to find a certain remedy by having recourse to the laws for all injuries or wrongs which he may receive in his person, property, or character. He ought to obtain right and justice freely, and without being obliged to purchase it, completely and without any denial.
At the time that was written, those are wonderful words, but indeed filing fees existed. That's actually how clerks of courts got paid. They got paid by the filing fees paid by litigants to get into court. So there's nothing new or alarming or surprising about filing fees, I don't think.
Certainly not in civil cases. And I don't think there's anyone who would disagree that if you want to bring a tort action or an action in contract against someone else, that a filing fee
This is
is
civil.
entirely appropriate.
Okay, I hear you on that, and I'm just asking, do you know of any other circumstances where the state imposes a fine, a monetary penalty against a citizen, and they have to pay to get any form of review at all? Is there any, other than this have to pay to have a clerk hear your case?
I'm not aware of there being any. I mean, this matter comes up as the result of state action. A police officer issues a citation. That's certainly state action. A citizen who feels that there's something wrong with that citation, they weren't responsible for it. The only way that they can even be heard, we're talking about the right to enter the room
He's
and
agreeing
appear
with
in
you.
front of a magistrate.
He's agreeing with you.
Pardon me?
Yeah, I am. I mean, I see a difference between the right to contest a state action and the right to appeal. I mean, I think I see a difference between the $50 charge for appealing to another level of the judiciary. That's different from saying that in order to get any review at all, you have to pay. And in this case, the only place you get initial review is in the clerk's office, right? There's no other administrative agency you can appeal to first to get a fair hearing?
And forgive me for not recognizing that you were in agreement with me, Your Honor. I think that also, in terms of the right to a de novo hearing, is that the dilemma presented is that, as recognized in the case of Redding versus Murray, a 1989 case, which was the case in which this court held that a person doesn't have a right to be confronted by the police officer at that initial hearing. And this court recognized that the evidence that may be presented against a defendant before a magistrate may not even necessarily be the type of evidence would normally be admissible even at trial. And that de novo hearing before the judge is really a hearing on a clean slate. And that is that all errors and irregularities in the proceeding below are rendered immaterial. So that the first hearing before the magistrate is the instance where the offender appears in the first place and is hopeful of being able to be determined to be not responsible. But this court has recognized that there are considerable infirmities in that hearing, and that the first instance where the regular rules of civil procedure apply and where irregularities and errors may be corrected.
But are those constitutional questions? I mean, the process is surely a limited process, but is it an unconstitutional process?
It is if it proceeds only upon payment. If a person has to pay money in order to be heard, to enter the room and address the court, then that, in my view, is violative of Article 11 of our Constitution. That the payment of a fee just to be heard violates that provision.
Why? I guess I'm confused as to why you think it's okay to charge a fee. I mean, accepting your argument, why is it okay to charge a fee to bring a tort action, but it's not okay to charge a fee for you to go from the clerk magistrate to the judge?
Because what is implicated, Your Honor, is state action. The issuance of the ticket to a motor vehicle driver is an allegation by a police officer that person has violated a statute of the Commonwealth, that they have violated some rule of the road.
Okay. So if in any 30A case, you have a wetlands protection problem, and the Department of Environmental Protection decides against you, doesn't give you a permit to build Cape Wind, and you're going to go into the Superior Court to challenge that, you shouldn't have to pay because it was state action that denied you that permit?
There's an argument there. I'm focusing purely on the people that are driving on the ways of our Commonwealth, who are stopped by police officers and who receive a ticket. That's state action, and that's a and
Those at state action to deny the permit.
Oh, well, I think, I don't know whether there have been contests of that. I'm not familiar with that area of the law. But what I'm saying is that it isn't police action. Maybe it's an action by an enforcement facility. Maybe there should be a waiver of a fee in that instance as well. But I'm talking about citizens who are stopped by the police, which is state action.
We have an indigency, there's an indigency provision in this statute.
There is, Your Honor. The dilemma presented as the standard there is one that says that a person may apply for and receive indigency status if they're not able to provide for the necessities of their family. And there are a large group of people who receive motor vehicle infractions who maybe live from paycheck to paycheck, or people who have modest means, and who can't truthfully sign an affidavit saying that they're without the ability to provide for the necessities of life, but for whom paying $75 in cash in order to have a second opportunity to be heard by a judge in what this court has recognized as really the first truly adversarial proceeding before the officer that gave them the ticket. I mean, that's my argument. I mean, and I wanted to touch briefly on an argument I also raised and make note of the fact that this court had approved the Uniform Rules on Motor Vehicle Infractions in 1986. And in those rules, it states, in those rules promulgated by this court, that there shall be no filing fee for such appeal. And I would just point out that fact, that this court made that statement in the rules of civil procedure that apply to the Uniform Rules on Motor Vehicle Infractions.
Isn't it pretty clear that on those kinds of issues, if a state statute has a different provision than the rule, that the rule cedes to the statute? We just decided that last year in the case.
Well, I understand that is the statutory rule. I'm just pointing out the fact that this court announced before the institution of this unconstitutional statute that there would be no fee, and I'm pointing that out in my brief, and I'm asking this court to please declare these fees unconstitutional. Thank you.
Mr. Sullivan.
Good morning, and may it please the Court. William Porter, Assistant Attorney General, here on behalf of the interveners, the Attorney General, and the Chief Justice for Administration and Management.
Mr. Porter, can you answer Justice Cordy's question? Is there any other area that you're aware of where, in order to get any hearing at all to challenge the action of somebody, state person, you have to pay a fee? I mean, so he's focusing on the $15 fee, not the
25.
I mean, the $25 fee, not the $50 fee, right?
Yes, Your Honor. I think there are at least three major areas, and Your Honor has already touched upon one. Those that come to mind, though, to my mind at least, would be if an individual wants to challenge a tax assessment. Let's just say it's a real estate tax assessment where the local board has not acted on an application for an abatement. Their first remedy, the taxpayer's first remedy, is then to go to the appellate tax board, to pay a filing fee, and in that event, to pay the tax before they can be heard at the ATB. That scenario was upheld in the Old Colony case, which is cited in our briefs. So that's one clear and very broadly based.
I'm not familiar with the tax abatement process, but in other words, in order to get any review at all, you have to pay money. Any review, even at the local level, some opportunity to be heard and say, you know, this isn't right and these are the reasons why. Some decision, you have to pay to get that decision, even at the local level.
Not even have to pay the filing fee. You have to pay to play. You've got to pay the tax.
You have to pay to play at the appellate tax board. And you have to pay your tax on time in all events.
Sure.
The reason I specified situations where an application for abatement is filed and then not acted upon, after a certain period of time, a local application for abatement is deemed denied. And in those cases, the taxpayer has had no process before the local assessor, and their remedy is to go to the appellate tax board. In other situations, Justice Cordy, it is the case that a taxpayer, when they file for an abatement, if the local taxing authority engages in their application, they may get process, and I honestly don't know on the local level, city by city, what the fees are, if any, but they certainly have to pay the tax. But there's clearly a large category of cases where individuals go to the appellate tax board, having had no prior process, have to pay a filing fee to contest a governmental assessment, along with obviously paying the tax on time. That's one very large category of cases that it's well settled, it's uncontroversial, and the rule that Mr. Sullivan argues for in this case would bump up directly with that. Another category, as Justice Botsford pointed out, is in administrative reviews. And an example is exactly the one that Justice Botsford referred to. Under Chapter 21A, the Department of Environmental Protection may make civil administrative penalty assessments for any of a broad range of environmental violations, including improperly filling a wetland or other such violations. In that scenario, for the individual who has received the administrative penalty, they may get a hearing before the Division of Administrative Law Appeals, but after paying a filing fee to the, it's at the Department of Environmental Protection, but a filing fee is owed in that situation.
To the department. So
To the
to
department.
repeat, to essentially contest an administrative action of that sort within the department.
Exactly.
You have to pay a fee to contest.
To obtain the formal hearing.
Well, is there some other review that you can get without paying a fee?
Well, I'm not precluding some informal back and forth with
Before the final
department.
decision or something.
But
like that.
what I am saying is that the first adjudicatory hearing that will yield a final decision, subject to judicial review, calls for a filing fee. And another example that comes to mind is if an individual receives an order of taking issued under an eminent domain power. If they're not satisfied with the pro tanto, they'll need to go to court to challenge that. And that, of course, would take a filing fee. I think in all these situations, we have very common scenarios where there is a presumption of regularity to the governmental action. The governmental actions are challenged under well-defined processes, and in those situations, a filing fee must be paid in the first instance.
Now, is there any limit to your argument in terms of the amount to be paid? I mean, what, for instance, if the legislature said these traffic citations are a burden on the court, we really want to discourage them, we're going to make the fee $1,000. If you're indigent, you can get that waived, but for the rest of the world, it's $1,000, even though the fine may be no more than $100.
Under the equal protection standard, which is the argument that Mr. Sullivan has raised, the fine can't be arbitrary, not fine, the filing fee cannot be arbitrary or irrational.
Well, let's assume it's not arbitrary. Let's assume that somebody's done a calculation that says it costs $1,000 to effectively administer and litigate these matters, that
Well, I
cost
don't
is
think
the
it's-
cost to the court.
None of the cases would address the cost of litigation that broadly. To the extent the cases have found constitutional concerns with filing fees, there have to be two elements. The right to be vindicated can only be vindicated in court. And secondly, it has to be a fundamental right. And the Supreme Court has taken a very narrow view of what rights are so fundamental that the state...
Like body?
Body and MLB are the two cases. In Body, it was the right to file for a divorce. In MLB, it was the ability to take an appeal from a termination of parental rights. Both cases, the emphasis was on the important and fundamental dimension of these familial relationships and the fact that certain individuals were entirely precluded from going to court because fees or transcript costs were required and the state did not waive those. In Massachusetts, we tend not to have these kinds of cases, of course, because we have a very broad provision in this Commonwealth for waiver of fees for indigents, and it's a very simple, straightforward process. So we don't, and it extends to all civil, criminal, and juvenile cases, so we tend not to have the cases that push up against the boundaries of fundamental rights because no litigant in Massachusetts who is indigent is deprived of an opportunity to go to court.
Okay. But going back to my question, would $1,000 be permissible in this instance? It's not a fundamental right.
For the clerk magistrate hearing?
Yeah.
I think $1,000 would very likely be held to be arbitrary by this court.
Okay, and
Yes.
why is that?
Well,
Why is that arbitrary and this amount is not?
Well, because it's an amount that obviously reflects no balancing at all of the obviously rational justifications for the fee that does exist here, the $25 fee. That's justified. as an attempt to defray part of the court costs and an attempt to make a litigant at least think once, if not twice, before they go to court. $1,000 would be so high that it would likely exceed any of the value of the rights at issue in most, if not all, cases. But I'm not. I would encourage the court to remember, though, that the equal protection cases do not call for a proportionality analysis. That's essentially what Mr. Sullivan calls for. He would like due process and equal protection to say that if I only have a small claim, I only have to pay a small fee.
But so let me just follow up with Justice Gantz. Let's say it's a one issue, I take it, if it was $1,000 for the clerk magistrate's hearing, and that's the first time you get to challenge this, is that it's a sort of combination, what's really a due process problem in one sense, in the sense that if you posit that you have a right to a reasonable hearing in a reasonable time, reasonable manner, and that's the hearing, because that's the only one you're going to, you don't have any before that, that can't be. So you have a right to some kind of process, and you can't put $1,000 on it if it's doesn't have some justification. Is that?
I think that's right, Your Honor. The case we would cite and have cited for the outlier example is Lindsay versus Norman, where the Supreme Court held that a requirement that a tenant who wanted to seek an appeal from an eviction pay a bond in the amount of twice the rent accruing during the appeal process. And that, the court found, was kind of the outer limit that it would, and there was no waiver provision either, so it would bar those tenants from that relief. But I think, Your Honor, it's important, as Your Honor has, to focus on the first level of review, because if there is any due process implication here, our position would be that the process that is due is delivered at the clerk magistrate level. The fact that the Commonwealth offers a second level of review is certainly an advantage to those who are cited for moving violations. But constitutionally, our position is, and the Ortwine case supports this, that second level of review is not even constitutionally required.
Mr. Porter, let me ask you, from the perspective of the average Joe who's involved in some kind of motor vehicle parking problem or whatever, what's the message here? You got to pay to have your day in court.
The message, I think, for those in this case who receive moving violations is that we have a very important public safety program here. It's to keep the roadways safe. When individuals are cited for moving violations, there is a process that's readily available to contest those. The process is not free.
And you have to pay.
So individuals are asked to make a modest payment.
So my question is that fair?
I believe it is, Your Honor. It's really a balancing between the maintenance of both the program, the public safety aspects of the program, and also the judicial aspects of the program. It's a balance between just the ability to maintain that and the ability of individuals to get some review.
Do you factor in the potential for a surcharge for individuals in their insurance so that it's not just the
Yes.
$25, it's not just
Yes.
the $75 ticket, it's whatever the insurance increase might be for multiple years?
Absolutely, and I think in many cases the insurance issues could exceed or maybe very substantially exceed the amount of the fine. There's a lot more at issue than a single violation. An individual always wants to avoid any moving violation that will cause surcharge points to be added to their automobile insurance. Each surcharge point for an experienced driver, at least in 2006, increased the base insurance rate for 4 coverages by 15%, and that's for each surcharge point.
I think that's Chief Justice Allen's point, that if it's got these terrible consequences or significant consequences, is it fair to make you pay to get an independent adjudication of the validity of the citation.
I think it is fair, because enough is at stake, I think, to ask those who are the recipients of civil, these are civil citations.
Well, surely you actually want to have a check on that, presumably, and one thing that a review gives you systemically is that someone is, there is a possibility that someone could contest, and therefore those law enforcement officers who are writing these tickets aren't just writing them to raise revenue, they're writing them because they're actual violations. Right? So it's important to have somebody contest from time to time.
Absolutely, and the fee where it's set certainly permits of that.
Would you, is it your view that you'd have to have some process? I mean, you couldn't just pass a law saying, you know, tickets are reliable, people should pay them, there is no right of review.
The issue isn't raised in Mr. Sullivan's brief, but I do not see a way that we could argue that some process isn't necessary.
You need the clerk's hearing.
Well,
I mean, it doesn't need to be that remedy, but you need something beyond the officer just giving the citation.
I believe the individual needs an opportunity to be heard. I don't think it needs to be before a clerk magistrate.
Right.
It could be an entirely non-judicial setting. But in this case, the legislature, I think, has balanced a number of things. They've provided first-level review in a judicial setting and then second-level review before a district judge. But it comes at some expense. And the reason I emphasized that the consequences are more than just the fine is because of the insurance issues, is that is a choice. It's the kind of choice that individuals virtually always face when they decide whether to go to court to try to vindicate a right, is whether the costs of doing so outweigh the benefits. And in a civil proceeding, that's a calculation that equal protection and due process analysis permits us to put upon litigants. We do not have, in civil matters, a right of free access to the courts. That was held in the Longval case, which required inmates to pay a portion of their account to file actions in court. There is no fundamental right of free access in civil cases, and the fine here should be upheld, at least on that basis.
Thank you very much.
The filing fee, I should say, not the fine.